Hey everybody, Crab and Cass coming at you. You're listening to the song Heartbreak on Sandy Run Road. That is the song that Crime and Cask Records helped produce for none other than Mr. Stephen Smith, which is the case that we have solved. If you want to check that out and what we think about that, you can read about it at crimeandcask.com, or you can go over to, let me turn this down, or you can head over to ccnewsnetwork.com and check it out. Okay, so I'm doing some new things here. This is new on TikTok, so we're recording live, I think, on TikTok, and we are recording live on the YT. So here we go. Let's get this voice thing down. I hope we're getting it right. And what we're going to talk about today, we're going to talk about what, of course, is Alec Murdaugh. However, what I want to talk to you about is an article that I wrote this morning, where our United States Supreme Court ruled in favor of an Oklahoma woman who is on, I'm on TikTok, so how do I say this? Unalive row. She's inmate Brenda Andrew. And what's important is how this could set the table for Alec Murdaugh. And I'm going to explain. So, as I said, the United States Supreme Court. Now, follow me on this Brenda Andrew story, because I'm going to then tie it into the Alec Murdaugh story and his appeal with the South Carolina State Supreme Court. So here's what happened. Let me show you a picture of this woman here. Let me see if I can't share this and get real fancy. Share screen. Oh, look at me. Whoops. Crap. Let's see if I can adjust that for you. Come on. No, I can't. Well, that sucks. Okay, so this is the woman who, Brenda Andrew, and she has alleged to have killed, unalived her husband, and she did it allegedly with her boyfriend. But the Supreme Court, she went to the United States Supreme Court, and they found that the Denver-based 10th U.S. Circuit Court of Appeals, they had erred in rejecting Andrew's argument that her 14th Amendment due process rights were violated by the prosecution, and their emphasis on her sex life and her personal behavior. All these words. And so what they say is that this is the quote, the right to the due process under the Constitution forbids the introduction of evidence so unduly prejudicial as to render a criminal trial fundamentally unfair. And the Supreme Court stated that in an unsigned opinion. And so the case now returns to the appeals court for further litigation upon Andrew's habeas corpus claim. So just a quick background on it. She is now 61. She was convicted of unaliving her husband. Her husband's name was Rob Andrew. He was fatally pew-pewed with a SHOTGUN in the garage of their former family home in Oklahoma City. So here's what prosecutors alleged, that her and her boyfriend did this. By the way, he is on unalived row as well. They did this and plotted to do this for life insurance. So interesting. So, but here's the thing. For her, during the trial, the prosecutors focused heavily on her personal life. Sound familiar? Presenting evidence of her extramarital affairs, provocative clothing, and alleged sexual advances towards young men. And a prosecutor even displayed her thong underwear. how I missed this, I don't know. Asking if the jury if a grieving widow would wear such an item. There's times during the Alec Murdaugh trial that I was like, I can't believe they just said that, but they did. Apparently, they allegedly called her a slut puppy. I don't think I've ever heard that term. But the state disputes that it was not referenced to her. I don't know who else they were putting on trial, but it was her. Now we get to the meat of this thing. How could this United States Supreme Court decision affect the Alec Murdaugh appeal, which is currently with the South Carolina State Supreme Court? They filed a 132-page brief back in December, and the state of South Carolina has just asked for a 90-day extension to respond to that. And then once that response is in, the Supreme Court will start making some moves. But here's the thing. So Murdaugh's legal team had argued to the South Carolina Supreme Court that his unaliving trial of his wife and his son was fundamentally unfair, and they are also invoking the 14th Amendment's due process clause. That is to challenge the inclusion of extensive evidence of his financial crimes. Remember that week of boring financial crimes. And originally, Judge Newman had said financial crimes can't get in. State of South Carolina, I forget what law it is, but you can't bring in prior crimes. So it was originally out. And then, of course, Jim Griffin asked, I think it was Nolan Tootin, one of the guys, can you think of any reason that Alec would do this? And of course, his answer was no, and that opened the door. And so the financial crimes were allowed in by Judge Newman. And in their 132-page brief, they are citing that shouldn't have happened. And they're citing 14th Amendment due process clause, that his rights were violated when the court allowed the prosecution to introduce prejudicial evidence that overshadowed the central issue of the alleged guilt of the unaliving of his wife, Maggie, and son, Paul. Specifically, in their 132-page brief, the defense claims that the financial evidence which detailed the embezzlement, detailed him stealing all the bad things, and the fraud was presented. Remember that? Did you look him in the eye, Mr. Murdaugh? Did you look him in the eye when you stole their money? When you look him in the eye when you lied to him? It was presented in such an overwhelming volume that it painted Alec as morally corrupt. And it did, effectively influencing the jury against him. And we're going to get into that in just a second, because drawing parallels to the Supreme Court's recent decision in the Brenda Andrew case, where the court ruled the undue focus on personal and irrelevant details rendered the trial fundamentally unfair. And so Murdaugh's legal team is going to argue that the financial crimes were irrelevant to the charges at hand and improperly served to malign his character. Okay. And this is what they say in their appeal. Murdaugh's attorneys state, and I'm going to read it. This is, quote, providing Murdaugh with a fair trial that every citizen of South Carolina should expect for himself is necessary to assure that no one, powerful or humble, innocent or guilty, hated as he is, Murdaugh, or beloved, is proscribed from due process and the equal protection of the law. The defense further emphasizes that the trial court permitted the introduction of improper character evidence and other irrelevant details that stated that in their brief. They go on to say, and I quote, so infected the trial with unfairness as to make the resulting conviction a denial of due process, 14th Amendment. And the appeal raises critical questions about the balance between presenting motive, which the state does not have to prove motive, at least in South Carolina, and ensuring fairness, which he did not get, which echoes the broader concern about whether the scales of justice were tipped too heavily against Murdaugh in a case that really captivated the nation. Now, talk about influencing the jury. The Murdaugh team is stating that it influenced the jury, and it is loud and clear, and it was heard loud and clear by the jury, because I don't think I have a copy of the book here. I got a copy of my other book. Juror 785, now known as Myra Crosby, also known as the Egg Lady, she made a reference in her new book, Because Enough is Enough, which is available on Amazon right now. If you're interested at all in the Alec Murdaugh trial, you have to go read what this juror has to say. It is just earth-shattering, mind-blowing, and you're going to just be mad. Even if you hate Alec Murdaugh, and he's a bad dude, he stole from people, he's awful, I get it. But as they said, even if they're loved, even if they're hated, even if they're bad, they are at least entitled to a fair trial. But Myra states in her book, Because Enough is Enough, and she wrote, the defense argued that since Murdaugh had not actually been convicted of financial crimes yet, it was unfair and prejudicial for the prosecution to grill him about those allegations at length during the Murdaugh trial. His attorney, Dick Harpootlian, he expressed concerns that letting the state go into great detail about the financial misconduct could risk confusing or misleading the jury about the actual unaliving charges at hand. Crosby goes on to write, Dick was 100% correct on this. She says, as I stated before, out on jury smoke breaks, they all talked about Alec. So before the financial crimes, Myra says, before the financial crimes were admitted, nobody on that jury, nobody, according to her, nobody on that jury thought Alec was guilty. It was only after the extremely tedious and, let's be honest, she says, boring financial testimony that many on this jury changed its mind. After the financial crimes were allowed in, and in my opinion, Crosby's, wrongly in, this jury I sat on, many changed their mind on Alex's guilt. The smoke break talk turned, and the people now said things like, well, if he can steal like that, he certainly can unalive his family. That's not what she wrote. And she finishes up by saying, this 100% misled and confused the jury I sat with. And I said to myself, Crosby said, how the hell can you jump from stealing or unaliving your family when he couldn't even unalive himself or put the poor dog out of its misery? And that was the one dog that the guy that watched the dog said that Alec couldn't do it. He called him to come down and do it. So there's a lot of different things. So it absolutely goes right back to what Jim Griffin and Dick Harpootlian put in their 132-page brief, that it was prejudicial, and that the 14th Amendment is going to, the due process clause in the 14th Amendment certainly kicks in. And that is backed up by one of the jurors who wrote a book called Because of Enough is Enough. Go check it out on Amazon. I think it's like $22. You get it in 2 or 3 days. And yeah, so there is cause here. Not only cause, there's legal cause. And not only that, when you go back to the Brenda Andrew case, the United States Supreme Court has also said this in her case. But, you know, these contexts differ, and I get that. Andrew's case is more about personal character, although, you know, Murdaugh's case is really about personal character as well. Excuse me, even though his, you know, kind of revolves around financial crimes. But the legal principle of ensuring a fair trial under the 14th Amendment, that, ladies and gentlemen, is what ties them together. And again, come after me, say all the rotten things you want to. I don't really care. I really don't. And you know who I'm talking about. I don't really care because I think Alex is a bad dude. I'm with you. I agree with you. However, the man didn't get a fair trial at all. That I do, in my opinion, do agree with Myra Crosby. I do agree with Dick Harpootlian, and I do agree with the 14th Amendment in the Constitution of the United States, that everybody deserves a fair trial, and I believe he did not get one. So going back to Brenda Andrews, the 10th Circuit Court will now revisit Andrews' claim, examine whether the prosecution's actions undermine the fairness of her trial. But going back to Murdaugh, if for whatever reason our South Carolina State Supreme Court kicks this back, this is going to the now 4th Circuit of the United States Federal Court up in Richmond, Virginia, and he will get a new trial. I did a video the other day, and I did an article about something that Nancy Grace had said. I don't know, Las Vegas odds. I don't even know if Las Vegas has odds on this, but she said there was. Las Vegas odds on Alec Murdaugh getting a new trial are extremely high. And ladies and gentlemen, they are. He's going to get a new trial. You might as well just deal with it now. And I think the South Carolina State Supreme Court is going to allow that. So that's what I have to say about that. Follow me on all the social media. I'm on the YT. I'm on the F. I just got on the IG, and I'm certainly on the X. And if you want, you can subscribe to my website. Lots of different articles. This week, I'm going to be doing another trip to the Caden Moses house. We're going to be doing some crime scene investigations there. So there's a lot going on, a lot of cool stuff. It's $4.99 a month. Just check it out. It's at crimeandcask.com, Crime and Cask, CASK, or go to CC News Network and you can check it out there. But love you guys. I will see you later. And wonder if I can figure this out. Oh yeah, play a little Heartbreak on Sandy Run Road. Staring down paths both old and new. Each twist and turn. You can read my interview, my 4-part interview with Patrick Wilson, who Fitz News calls a person of interest in the death of Stephen Smith. I am the only person in almost 10 years to ever interview him, and I did an interview with him back in August of this year. Patrick Wilson, check it out, 4-part interview on crimeandcask.com.